communication. This was one I think that we just recently reset for a couple of weeks. So if you're in communication with Ms. De Leon, I'm good to just say, okay, you all were here. We should have some documents and moving on, so y'all don't have to wait. But Ms. De Leon may be showing up.
I am in communication. I can let her know.
Thank you very much.
Okay.
Okay, good morning. This is Judge Alyssa Perez presiding over the 210th District Court Civil Docket for July 16th, 2025. All matters being heard today are being heard in accordance with all directives regarding remote proceedings. In addition to that, we are streaming all matters live via YouTube for public viewing. I will call our first case. This is 2025. Wait a minute. Where's Walter?
He's in the voice room. He'll
I
be
just
back.
he's logging on, Judge.
Okay. Mr. Ramsey, you're free to go.
Thank you, Your Honor.
Thank you. We need our I guess we also have Christian Medina, our clerk.
Judge, I teamed him already. He should be getting on.
Thank you. All right. Walter, are you ready? Okay. Mr. Negrin, are you there? Mr. Negrin, are you there?
I am here, Judge. Sorry.
So let's do this again. This is cause number 2025 DCV 0542, Franz Pierre versus Claire Shamblin Clayton et al. May I have announcements, please?
Rob Negrin on behalf of the movement McCarthy Holthus LP.
Mr. Pierre, you're muted. I'm sorry.
Sorry, ma'am. Franz Pierre, the plaintiff.
Thank you very much. And gentlemen, good morning. We were discussing briefly off the record. We were scheduled last week on Ms. Clayton's special appearance, and subsequent to that hearing, that we were also set for a scheduling status conference. I believe, unless you all tell me otherwise, that the court ordered, and we were of the understanding that the McCarthy Holthus motion to dismiss, which was filed, I think the same day, I think it was July 9th, would be set today for hearing. However, notice was not sent from the court, and in fact, it wasn't on the docket this morning. But you all are here. And so in looking at the Odyssey entries, I do not see, oh, let me see. Hold on. I do have a verified response um, filed by you, Mr. Pierre. So I just need to know, because it was not actually noticed by the court, if you all are in agreement to proceed today, or if not, so that the court can either reschedule or just consider via submission now that I have a response.
We're
Mr.
ready to proceed. I'm sorry, Your Honor. For McCarthy Holthus, we're ready to proceed.
Mr. Pierre?
Ma'am, if you don't mind, can we schedule this at another time?
So what I will do is, because I have the motion and the response, the court will consider it via submission.
Understood, ma'am.
Okay. Yeah, that's how we'll do it.
Thank you, ma'am.
As I mentioned, so that you all are aware, the court, unless something happens, and something can happen, the court anticipates being in a month-long civil trial. So just please be patient with us. If things get filed and you're requesting it, we need those requests definitely to come in via email to Ms. Hernandez, and the scheduling will be a little tricky. Know that if there is anything that is filed, I can always take it up via submission, but I will be looking for a response. So if someone files something, just know that might expedite things. Maybe not. Maybe the trial doesn't go a month. Maybe it's shorter, and I can schedule you all. But I'm just giving you all the heads up, because I know, sometimes things can move very quickly.
Yes, ma'am.
Mr.
Your
Nick?
Honor.
Yes, sir.
Yes, Your Honor. I would like to speak to the procedure and just address the motion a little bit if I could, and that is that it is largely a procedural motion, Your Honor. It is a motion. It is a motion that was brought to dismiss my law firm because it was named only as a substitute trustee, and that is a requirement, and the court is without discretion when the events that have unfolded like they did here. The court is without discretion to dismiss my client and my law firm from this proceeding. I don't think it's anything that needs to be carried on any further than today. We're here, we're ready. The court told us to be here. The two parties that are of consequence to this motion are both before you. It's briefed. And we're ready to proceed because, Your Honor, my law firm has absolutely no business being in this lawsuit as a substitute trustee. Now, Mr. Frantz will tell you, well, it's because of some undomesticated judgment from the state of Virginia. Yet, Your Honor, or the Commonwealth of Virginia, yet, Your Honor, the pleading that was filed by my law firm sets forth both a note and deed of trust security instrument and assignments and notices of foreclosure completely and entirely unrelated to any of the claims made by Mr. Pierre in his lawsuit principally. In short, Your Honor, we're just trying to foreclose our interest in a piece of land that Mr. Frantz or Mr. Pierre owns and for which he signed a note and deed of trust, completely and entirely unrelated from any of the other claims made against the other defendants in this case. We're out here rogue, Your Honor, and we have followed the law under the Texas Property Code to have ourselves dismissed because we're only named as a substitute trustee, and we've not been named or accused of any wrongdoing with respect to the note and deed of trust that were executed by Mr. Pierre and that were part of our answer to the case. Further, Your Honor, the court further has no discretion because Mr. Pierre did not follow the Texas Property Code and file a verified response to our motion within 30 days after we filed it. And that, under 51007 of the Texas Property Code, is the death knell for his case against my law firm. We need to be out of this case.
Okay. So, Mr. Pierre, I have I am understanding your request for the hearing not to go forward today. I understand that to be your request. However, since Mr. Negrin has discussed some matters with respect to his motion, I'll give you an opportunity if you'd like to say anything. If not, as I said, I will take both the motion and your response, Mr. Pierre, under consideration via submission. That means that there's not going to be a future hearing date.
I understand, ma'am.
Okay. Did you have anything for the court, Mr. Pierre?
No, ma'am. Everything is already submitted in writing.
Thank you very much. Thank you for appearing today, and please, I do extend my apologies for that, not officially getting on the court's docket. But just as I was aware that because of the court scheduling, we needed to have this heard very quickly. I have that same mindset in terms of considering this matter via submission. In other words, don't expect it's going to be any longer than this week, because after this week, the court will be out of pocket.
Thank
Okay?
you.
Will we need to file a notice of submission, Your Honor, or is the motion considered submitted?
It's considered submitted. And what we will do at this point, just so that we have something, I believe what also should have been scheduled today was that scheduling status conference. I will set a scheduling status conference in this case for 30 days out. Okay, so at least we can have a point at which we reconvene. Okay,
Thank you, ma'am.
thank you for your time. Mr. Negrin, did you have anything else?
One final issue, Your Honor, and that is that the motion that's in front of you is, and the remedy that's allowable is dismissal of my client, of my law firm, without prejudice. If Mr. Pierre has other issues that he wishes to bring to the court against my law firm, he can file those appropriately. It's an order to dismiss my client without prejudice.
Thank you, Mr. Negrin. I will note that Mr. Pierre has immediately logged off. So
Sorry for the ex parte, Judge.
no worries. We're adjourned. Thank you very much.
Thank you.
Okay. Have we
Judge, I have
heard from the
Mr.
bad parties?
Yes, ma'am. Mr. Ormiston is the only one here right now, and he actually wanted to talk to you. His hearing's not till 10:15. Are you there, Mr. Ormiston?
Yes, good morning, Your Honor. I'm here.
Good morning.
Morning. Yeah, this is I'd conferred with Paul Grajeda, and I didn't realize we weren't on until 10:15 later, but I figured we
Page
might
5,
all try to
Judge.
get up in front of it. Oh, pardon?
I'm sorry, I was talking to Judge. Page 5,
Oh.
Judge.
And it's matter of 3531. Paul and I we've agreed that and again I'll let him speak for his client. We're going to dismiss our counterclaims against against Rocco Developers and the other parties, and they are likewise, to the extent that there's any claims remaining on their side, they are going to dismiss their claims against us. So the whole suit's going to be dismissed. Just wanted to,
How soon are
again,
we going to get those dismissals?
pardon.
How soon can the court expect those dismissals?
I would say I would like to have them to you this afternoon. Again, I'll let Paul speak for his client, but that's our intention, is to dismiss our case.
Okay. All righty. Well, is Mr. Grajeda going to log on?
I believe he is, but he may be a little more on top of his calendar than I am, and so
Can we give Mr. Grajeda a call, please?
Yes, ma'am.
Thank you. Okay. Thank you, Mr. Ormiston.
all right. Do you want me to hang around, or
Yes, please. Let me see if we can get Mr. Grajeda.
okay, perfect,
Just
perfect.
check you off.
Hi, Mr. Armiston. If you have a cell phone number for Mr. Grajeda, maybe you could give him a call. His office is not picking up.
Okay,
Thank
I'll
you.
try to call him.
Thank you.
Yeah, I just left him a voicemail.
Okay, I thought maybe you had a cell phone number for him because his office is not picking up.
Yeah. I tried a cell number and it didn't. Just went to voicemail.
Thank you.
Oh yeah, no, thank you.
Mr. Nunez, can we go ahead and get off of YouTube?